In a contract for the sale of goods, the seller's non-performance may be excused if it becomes commercially impracticable. Commercial impracticability doesn't mean literal impossibility, but it imposes a high threshold, which the North Carolina Court of Appeals explored in Alamance County Board of Education versus Bobby Murray Chevrolet. In April of 1989, the state of North Carolina invited Bobby Murray Chevrolet, a General Motors franchisee, to bid to sell school bus chassis to certain North Carolina school boards. Bobby Murray submitted its bid after consulting with General Motors, which would manufacture the chassis. Bobby Murray's bid prevailed. The resulting contract didn't reference General Motors as the manufacturer, though the bid specified that the chassis would be Chevrolet brand. General Motors controlled that brand. Meanwhile, the federal government enacted new emissions regulations to take effect on January 1, 1991. These regulations would effectively ban the chassis here. Further complicating matters, the materials needed to manufacture the chassis became scarce. In early August of 1990, General Motors informed Bobby Murray that this shortage might push back the production schedule. Later that month, General Motors stopped accepting new orders due to the shortage. In November, General Motors canceled certain prior orders. Finally, in December, General Motors stated that new chassis would be available only after the regulation's effective date. Bobby Murray then alerted the state that no more chassis would be supplied. The school boards obtained the chassis elsewhere and then sued Bobby Murray in North Carolina State Court for breach of contract. The trial court entered summary judgment against Bobby Murray, which appealed to the North Carolina Court of Appeals.